Good. I think we can start this morning or evening or afternoon. So welcome to this third episode in our webinar series on Investment Mediation Insights. We're glad you joined us this time around, or if you're recurring visitors, glad to have you back. Starting out with the good news that I wanted to share is that ICSID has released last Friday our working paper number 6. In 2018, we published working paper number 1, where we originally proposed ICSID's mediation rules, and down the road we are now at number 6, which is intended to be the last, and the rules are anticipated for adoption in early 2022. As we know, parties are free to agree to use the mediation rules in their current state and request ICSID's administration of investment mediation, which has also happened in practice already. So besides the rules, ICSID has been busy on investment mediation front and published a background paper on investment mediation, as well as an analysis of investment treaty provisions on mediation. And Damon will put in the chat links to these documents so that you have easy access. We've also supported Working Group 3 on investor-state dispute settlement reform and our friends at UNCITRAL, contributing to drafting to notes of the UNCITRAL papers that were recently discussed in the intersessional in Hong Kong. We are also doing investor-state mediator trainings, and one is coming up in January that we invite you to sign up on, and also Damon will put that in the chat. So besides all of that activity and our blog series that we publish on investment mediation, we have this webinar series where we really want to show investment mediation is not just a good idea, but actually happening in practice. And the last 2 episodes, we've had policymakers on the first episode talking about domestic legal frameworks and the treaty framework. And last time we talked to 2 experienced investor-state mediators. And today I have the pleasure of having James South, Chief Executive of the Centre of Effective Dispute Resolution in London with us, who is also an experienced mediator and has done lots of training on investment mediation, and Lawrence Boo, who many of us know as arbitrator in investment arbitration, but who is also active on the mediation front and has extensive practical experience. So welcome to you both. I'm happy to have you here with us on the panel. So what's the format for the next 40 to 45 minutes? We'd like to have this as an informal conversation with James and with Lawrence. And please, if you have any questions you'd like to add, please put them in the chat and we'll pick them up when it's a good time for the discussion, either during the webinar or at the end. So with that, let's get right into it. And that is, let's start with a bigger picture, James. Maybe I start with you. So investor-state mediation, is that just a good idea? Is it possible to mediate with public entities or state? What are your thoughts from your experience?
Thanks, Frauke, and nice to be working with ICSID again. One of the things we often hear when we've been talking about investor-state mediation is, well, investor-state disputes are very particular and they can't be mediated. But I've been mediating for 25 years in all different types of disputes and international commercial disputes with government bodies and in over 30 countries. And if I had a dollar for every time I heard, well, this type of dispute can't be mediated because then I'll probably be a rich man and wouldn't need to be a mediator. I mean, the reality is most disputes can be mediated. All we're talking about is a facilitation of facilitated negotiation to help settlement. And given the fact that most disputes in society generally settle, and I think even you have statistics at ICSID to show that there's a lot of settlement investor-state cases anyway, there's no reason why investor-state cases can't settle and can't be mediated, and indeed I know they are mediated. And there are other areas in society where states have been involved, like tax disputes, where again they are now successfully mediated where they weren't before. But that's not to say that there aren't issues to be resolved. There are issues around authority to negotiate and to settle, around accountability, etc. But those are all issues which have been addressed in other types of disputes and can be addressed in investor-state disputes.
Mm-hmm. Yeah, interesting. I found it particularly interesting in how many jurisdictions actually tax disputes can be mediated. That is such a sovereign matter. It's way beyond like the UK or the US. But Lawrence, turning to you, what are your thoughts on mediating investment disputes? Right now we cannot hear you, Lawrence.
I say I'm quite disappointed. I thought I was supposed to disagree with everybody, and so we take a contrarian view. But I must say that I agree with James that, I can't see why that we are so hung up about saying that states should not be involved in mediation. Historically, disputes between states do get resolved through different forms. Sometimes they go to a war. Sometimes the spectrum of methods of dispute resolution varies. Wars, sanctions, embargoes on one end, and negotiations, mediations, resulting in peace treaties. In more recent years, countries enter into trade agreements, multilateral treaties through facilitated negotiations. They are essentially a higher form or a more complex form of mediation. So mediation of state disputes and investors, and non-state entities and states should not be very different. In fact, one would expect that in terms of power differential, a non-state entity may have a degree of disadvantage compared to states. So I don't see why states should not go to arbitration. From a macro level, actually, there's no logical reason. On a micro level, maybe we can talk about that in terms of the government servants and civil servants and the people who handle state matters. Maybe they are a little bit hesitant. We may examine questions why they are hesitant. But on the macro level, I can see state parties should not shy away from mediating disputes.
Mm-hmm.
I don't think that there is any impediment at all.
Thank you both.
And that's why I agree,
Sorry.
James, totally.
Can I just add, Falco, I mean, the international commercial, of course, disputes, which in essence investor-state cases are, they're commercial disputes, right? Then they are mediated all the time, and governments, send party representatives in commercial matters to reach resolution with commercial parties. So we have evidence, and we know it can work in other commercial cases. So why can't it work in investor-state commercial?
Yeah. And that is, Lawrence mentioned that even in the ICSID arbitration cases, when parties try to resolve it by arbitration, about 30 to 40% settle of those. And then, of course, there's all the other cases that don't come to arbitration, which our colleagues from the World Bank estimate that only 6% of investment disputes actually end up in arbitration. So in that sense, and from our research, we know of a number of investor-state mediations that have already taken place. We just don't know a whole lot about it. So that is confirmed by the practice. But now, another myth that we often hear in our arbitration-oriented investment dispute settlement world is mediation just a talk shop? What actually happens there? James, why don't you start enlightening us a bit on that?
Well, if it was a talk shop, then the statistics disprove that, because we know that almost internationally across the board in Singapore, London, wherever you may be, statistics show that 70 to 80% of mediations settle and result in some form of settlement. So that proves as a concept that it's not just a talk shop. And even if it doesn't settle, and Lawrence might want to pick that up, I know because he's talked about it. It will substantially narrow the issues in dispute, and there'll be resolution on some, but there may be a gap for some which maybe need to be arbitrated or litigated, or perhaps subsequent discussions in order to close the gap. But statistics will prove that it's not a talk shop.
Lawrence, over to you. Talk shop?
No, certainly it's more than talk shop. And if it is talk shop, it's very effective talk shop, isn't it? And to have parties coming together and resolve their disputes together. Mediation is assisted or facilitated negotiations. Parties come with serious issues and wanting to resolve them and do get them resolved from 70 to 80% from the data that we have in Asia, and in China even higher. So it is, if it is talk shop, it is well worth talking shop and getting matters resolved, where parties meet their respective interests and have their problems resolved. And so whatever label people tend to give to mediation, it doesn't matter. So long as it works, why not?
Maybe we actually change the name of our organization to the Center for Effective Talk Shops.
Maybe that's a great idea.
It seems to be very effective. But James, CEDR has a process map for mediations. And for those of our participants who are not so familiar with mediation, would you mind taking a minute to outlining sort of the different process steps that you came to?
Yeah, I mean, I think like any good process, you need to prepare. Any professional process, there's a preparation stage, both for the mediators, but also for the participants and their advisors. So that's key. And a lot of work in investor-state mediation in the preparation stage about what the process is going to look like, because it is, it is complex and complicated. And then you have on the mediation sessions itself, you'll have some form of ritual opening, if you like, where the parties will make their opening, often around the legal positions as they currently understand them, and perhaps the commercial drivers. And then the mediator is not going to jump straight to giving their view or giving solutions, but mediations is facilitated negotiations. What's important are what are the parties' interests, what's driving them beyond the legal interests. So in investor-state cases, there'll be political motivations, there'll be commercial motivations, and there'll be others as well. And the mediator has to work with the parties to find them out. That's a process called exploration. And at that point, once the mediators understood the range of issues and the parties have understood the range of issues, at that point, then the parties with the mediator assistant begin to make offers, narrowing the gap between them, hopefully at the end, reaching some form of agreement. It may not be right in the middle, it may be left or right of either party's negotiation range. That's essentially the process. And then, importantly, it is enforceable because an agreement will be written down in writing, in contract, and can be enforced through various mechanisms in local jurisdictions and also with the Singapore Convention.
Please add.
One of the important features of mediation is that the mediator or the neutral help parties to see beyond their own problem, help them to see the interests of themselves as well as the other party, and to help build a solution together. And it is this collaborative way of problem solving that mediation is effective. Unlike arbitration, unlike litigation, where it is someone making a decision for them, here they are building together the solution, and therefore they want to carry it out. So the effectiveness, I think, is in the fact that they work together to find a solution. And that makes a lot of difference in the outcome.
That the solution is developed by the parties rather than by the third party body, whatever that might be. So James, sounds like mediation isn't really informal arbitration, another myth that we often hear. Oh, I see shaking heads. Who would like to go first? James, maybe?
Yeah, I mean, no. I mean, if you think of the range, if you think of litigation here, arbitration next to it, then you'll have mediation and you have negotiation. Mediation is more closely associated with negotiation. It is facilitated negotiation. It is an informal decision making or informal adjudication, because the mediator is not going to make a decision, shouldn't give their view right up front, definitely not. More, they're going to facilitate, as Lawrence said before, going to facilitate the parties' negotiations. So it's better to think of it as a negotiated, facilitated by a neutral, rather than some informal adjudication or decision-making by neutral. And that comes back to Lawrence's point. It's much more effective to get the parties to do it themselves. If I tell you what I think the answer is, then one side's not going to be very happy. One side might be happy because I probably favored them, the other side's not, and then they're not really going to engage with me on the subsequent negotiations, because they don't perceive me as impartial. So that process, if you were to do it, of giving a view at the beginning, and then negotiating around that just doesn't work. And we know that from years and years of experience. That's why mediators don't do it.
Mm-hmm. Lawrence, yeah, what are your thoughts on informal arbitration or mediator providing the solution?
No way, no way. That is not what we do here in mediation. We facilitate the negotiation. We do not give our views on the merits of the case. We want the parties to work towards a solution and not a mediator telling them who is right, who is wrong, what should they do in that situation. The role of the mediator is to help them see how they can work together, how they can formulate the solution together. And that's where the buy-in is. That's where they feel they own the solution. Yeah, I think it's really very important. Mediators do not adjudicate for the parties. They do not tell the parties, this is the way to do it. This is the way to resolve the problem. Otherwise, we are no different from being arbitrators or judges. I think some judges do attempt to mediate in that sense by telling the parties, if you don't follow my instruction and do this, I'm going to pass judgment against one or the other. We don't do that in mediation. Yeah, it is not our role.
So if we looked at, thank you both, if we looked at sort of the process of mediation and we touched upon the role of the mediator, in your view, what are then really necessary qualifications for an investor state mediator? James, would you like to start?
Well, I mean, I think as Lawrence and I are indicating, they need to be trained as mediators. I mean, it's a real skill set. It isn't just an add-on or something yes, everybody could have an element of a facilitation or mediation through their professional work, but it is a learned behavior with quite definite skills. So you need to be qualified and ideally have some experience in it. Would it be useful for mediators mediating investor state cases to have an understanding of the investor state context and the dynamic? Absolutely. So some training on that and actual experience on that is important. And I think the third point is credibility. These are important cases. They are complicated with sophisticated investor party and sophisticated state parties. So credibility of the mediator is also important in this space.
Yeah.
Lawrence, you'd like to add any?
No, I agree. I seem to be agreeing with James this whole morning, which is good, right?
I'll continue
it's
with
part
that.
Of mediation, agreeing. I agree, James, that training is essential because many of us or many lawyers who are involved in our mediation or believe that they can resolve disputes because we are trained in a way from an adjudicatory mindset or adversarial mindset. We want to judge things. We want to think this is the right way to do it. So lawyers need more training actually to undergo that mindset change when it comes to mediating or being involved in dispute, both as a mediator as well as counsel. As counsel in a dispute, which is before a mediation, he too got to learn to look at the problem from a problem-solving angle, rather than how can I win this argument? How can I persuade the judge or the mediator to have a better offer, to get a better offer from the other side in my client's favor? Really, the mindset has to change. And I think this applies both to state counsel as well as non-state entities, that they really need a mindset change in order to solve problems as big as complex as those between investors and states.
Mm-hmm.
I think it's important, and I think we're seeing a shift that these arbitration, mediation, litigation, negotiation aren't alternatives to each other. They are just processes in the toolkit of professionals, be it the legal advisors, be it the parties, to help them resolve a complex matter before them, whatever that may be. And it should be looked like that, and each require the relevant skill set to do them.
Mm-hmm, mm-hmm, thank you. To add for our audience, we've summarized in our background paper on mediation that Damon shared in the chat some of the qualifications and all the work that has been done by the International Mediation Institute. The IBI rules have something on it, the investment guide from the Energy Charter Treaty Secretariat, and that's all in our paper. But going back to what you just said about toolkit, James, and sort of the different processes, in your view, if a mediation doesn't settle, and you touched briefly upon it at the outset of our webinar, if a mediation doesn't settle, so is that just a further delay in trying to resolve the dispute? What is your view on that?
Lawrence, do you want to take that one?
Okay. I think I'll jump in first. I think I don't believe in mediation anything is wasted. There's no such thing as what a waste of time and money in mediation, because nothing is wasted. With every attempt at mediation, there is always something positive. Even if the parties do not settle at the mediation session, subsequent to it, they'll realize that they learned something of the other parties, as well as they learn something about their own weaknesses, because parties going to mediation or in any dispute resolution believe that they're always right. And that's why they are fighting like anything to just try to win a matter. But when they go to mediation, they realize that their position may not be as good as they think, and that the other party's position is not as bad as they think. So things like this happen in the course of the mediation, and the takeaways from them are often positive. And often, even if a mediation session do not result in a full settlement, the parties eventually do settle. And even if they don't settle, their expectations will often be moderated. Eventually, they will come to a solution. So I'm always very positive that it's so long as the difficulty is getting them to go and mediate. The difficulty is persuading them that there is a positive outcome in attempting mediation. I think that is always the challenge.
Thank you. James, do you have anything to add to Lawrence's thoughts? Yeah? Then I move on to the next portion, which is also what we touched upon on the toolkit. And now we look at chronology. And Lawrence, maybe you start with that again. Like, where is mediation and arbitration? Last time on our episode, we looked at combination options, but is mediation only option ahead of arbitration, or how do you see that?
Well, I think in any dispute, mediation should feature, and mediation can come in at any stage of the parties' timeline in the dispute. Mediation should be available anytime. No attempt at mediation is a bad time. I always think it's a good time for mediation, but sorry, I don't think there's no bad time for mediation. The question is whether this is a good time for mediation. In other words, there might be some windows which are better windows than others. For example, sometimes you want to commence, you're very enthusiastic in wanting to mediate, but then the other party is just not ready. So it is a matter of getting both parties ready to talk to each other, ready to negotiate, ready to discuss the issue. So generally, the earliest stage, of course, in mediation, you start early, it might be good because that will save some time and cost when it's settled, but it's not necessarily the best time. I think the best time is when parties know each other's position, relatively have some knowledge of the other party's position as well. So premature mediation may not be as effective, but as I say, there's no bad time. It's always good, but there will be a good window. Of course, one also must be conscious, especially with state parties, there are issues of be careful of the legislative calendar of the state party, whether they are pending elections or elections are just over, there's a change of government, or maybe there's going to be a civil change in the leadership of the civil servants in the state or in the country. So these are things that one may have to take into consideration when it comes to state parties involved, and the sensitivities of some maybe religious groups or cultures in the state. So we have to be conscious of these things when it comes to state parties. That's about all. I think there's no bad time, but there will always be a good time. for
Looking at the suitability of mediation as a process can come at different stages and can be reassessed, right? If you originally don't think this may be the right process for you down the road, that assessment may change. And that is what we see in the more recent treaties, and the EU-Singapore FTA, for example, where mediation is built in at any stage. Parties can turn during an arbitration, prior to an arbitration. And I'm sure you as experienced mediators have also seen the mediation after an award was rendered. So on that, yeah. But coming to mutually agreed solution, it's not an award, James. So James, what's the point? As the arbitration institution representative, why would I think that a mediated settlement agreement that's not an award is a good idea?
Well, what's the purpose? What are you trying to achieve? You're trying to achieve a resolution to the dispute. And again, evidence shows that very few mediations actually need to come back to any form of enforcement. Why? Compared to arbitration, for example, or even litigation. Why? Because the parties have voluntarily agreed to the settlement, so they've signed up to it. So they normally comply with their obligations. And then, even if they don't, and for some reason they want to renege on their agreement, they are enforceable. So again, it is analogous to awards in that respect. They're either obviously enforceable often through the local jurisdictions laws, and also now in an international context, we've got sterling work that Singapore did to get the Singapore Convention on the enforcement of mediated settlement agreements. Those are enforceable in countries which have signed up to the convention. So we've got a real strengthening of the enforcement. But again, for me, that's just a more reinforcement that they are able to be enforced. The key message is 90%, 99% of the time, they don't need to be enforced because of voluntary agreements.
Yes.
Yes. Go ahead, Lawrence.
Yes, I think James is right on point there, that a mediated settlement agreement being breached is really a rarity. Yeah, I would love to hear, love in inverted commas, I really want to hear whether there is a case in which a party actually reneged from a mediated settlement agreement. And I've yet to hear one that goes to a Singapore court or a court that reports its decisions, because it's so rare. It's so rare. It's so rare that sometimes people even criticize, why is there a need for the Singapore Mediation Convention? But of course, the Mediation Convention is to plug the need for people, assurance that people will want to go to mediation, and not to have this argument by lawyers to say, oh no, don't go to mediation because the mediated settlement agreement is not an award, therefore not enforceable. I think the real point of the Singapore Mediation Convention is really to answer this argument, which in my view is a relatively good argument, but in reality it doesn't really happen. So don't be surprised that not many people will use the convention to enforce the mediated settlement agreement. So there will be not too many judicial judgments, decisions on the interpretation of the convention. Don't be surprised. I won't be surprised at all.
I completely agree, Lawrence, but I think that is important, as you indicate, to go to credibility of the mechanism to resolve international commercial disputes, including investor-state disputes. Right?
And to add on,
to give reassurance to the parties, maybe if they are reluctant, look, there are these mechanisms, along with moves such as ICSID having their rules and other institutions to provide that certainty. These are institutions that we know. And they have rules and there are mechanisms in place.
Yeah, and that halo effect of the convention, I think, has played a lot in the investor-state dispute settlement reform discussions into it. And from our statistics, what I can add is that those cases that settle in the investor-state arbitration context, out of about 300 by now, only about 2 or 3 came actually back about discussions alleged non-compliance. So that would support the statistics that you have seen as well. And in that context, the other point maybe to touch upon is that as we talked about, mediation can come in at different stages of the process. It may also come in alongside an arbitration, where parties could agree to suspend the arbitration, agree to mediate all or certain points of the dispute, and then come back to the arbitration level. And if it's an ICSID convention context, have an award with the enforcement mechanism under the convention. If it's otherwise, the New York Convention comes into play. So if enforcement is really a concern, there are different ways of addressing that. Okay, one other point I wanted us to look at a bit is the discussion about disclosure of information and confidentiality of the mediation process, which comes in with a state involvement, with some tensions between the two. And we've had those discussions with our member state during the rules development in our consultations. And the ICSID mediation rules do contain a provision on confidentiality with certain exceptions, of course, if disclosure is required by law, if the parties agree, or if it's otherwise needed for settlement. So what are your thoughts, James, you with your experience on mediation with public entities? How do you see that confidentiality and the transparency of a process or information disclosure?
Well, I think Lawrence might add to this, but I mean, I think clearly mediation needs to be confidential during the mediation process to work, because the idea is that the parties are open with the mediator in order to understand the full range of interests, and then to have confidential negotiations to reach settlement. Now, and it's often framed that the objection is often framed to confidentiality in this context as well, we need transparency. But you need what do you need transparency for? I guess is the question. And I think Lawrence, you might want to comment. I think it's really about accountability on the state side of things, not about transparency per se. Lawrence, do you want to pick that up?
Yes, I think I totally agree that all this talk about transparency is so bandied by many groups, including some lobbying groups. But really, the concern is not really transparency, it's accountability. If the state can account, or the state players can account for their actions, where is there a clamor for transparency? Insofar as the state is able to account for their actions, the resolution of the dispute by the state, for the state, is itself an achievement for the state. So I think accountability is so much easier when there's a mediated settlement agreement. And I don't think there's any tension in relation to the fact that the state has settled. I agree with James that the process, when parties are engaged in the mediation process, that is confidential. But when the result or when the solution is found, it's a matter of public interest. And the law will probably prescribe, allows the Prime Minister or the Minister for whatever ministry to disclose to Parliament to which they are accountable for what was the issue and how it was resolved. And I think, and it is no different from arbitration actually, or court litigation. In terms of confidentiality process and arbitration, of course, these will probably come within the exceptions. The disclosure would, to the extent that it accounts for the acts of state by the government officials, would suffice. And I don't think there's real tension with confidentiality.
Thank you both for sharing your thoughts. I've looked a bit in the issue, and I think on mediation, one thing to keep in mind is that it is actual negotiation. We come back to that point. So it is exercise of government function, and in that sense needs to comply with the domestic law. And the domestic law, when you look at that, public-private partnership legislation requires certain aspects of renegotiated concession agreements agreements, for example, to be made public. Or I think we need to differentiate here perhaps between confidentiality obligations, limits to confidentiality obligations, and affirmative disclosure obligations, to look at that range. And there, I would argue mediation is different from the arbitration system in that sense. And I think that is a really interesting topic. But James and Lawrence, from your commercial experience, commercial mediation experience, what is the practice with party disclosure, agreed disclosure during a mediation at the end? What is it? What have you seen in practice? Lawrence, maybe you start.
Well, I think in practice, if it is a public listed company, for example, often there will be certain understanding that a joint statement by them, agreement by them, that these are all accountable to the public, and therefore, even though there might be a confidentiality obligation in the contract, this has to be disclosed as a matter of law, statutory requirement. So when you come to big players in the financial market, the banks, insurance companies, and even the listed companies, they will, despite the confidentiality obligation covenant in the arbitration, they will still need to make some disclosures. So that's a matter of obligation, statutory obligation. So we can't hide behind confidentiality forever, you know. Of course, trade secrets and confidential information and state secrets as well. This has to be kept under wraps, you know, for public interest and also proprietary rights of parties. So those are generally accepted. I don't think any lawyer would dare to argue that no, those can be disclosed publicly.
Yeah, I mean, I'll tell you a story to illustrate the point. I was having lunch with a mediator colleague of mine the other weekend, and he told me that he'd mediated. I mean, he's from CSO. He was telling me he mediated this massive case, which was in the public eye here in the UK. And I had heard on the news that it had been settled, but they didn't say it had been mediated, they just said it had been settled. And then that week later, I found out my colleague was the one who mediated it. So these cases are in the public profile, in the public eye all the time, are mediated, and then the outcome is actually communicated to the public, the terms of the settlement, where there is a public interest, as Lawrence said. It's just often not mentioned that it's done via mediation.
Right. In fact, settlements newsworthy, especially settlements of big corporations and corporations and states are big news, and they are a matter of public interest. And I think the lawyers and the parties love to have them known to the public as well. Both parties really don't mind it being known to the parties, to the public when they settle.
Right.
They may not be happy when they lose a case, they don't want it to be reported, but when it comes to settlement, they are quite happy. You know, despite all the confidentiality agreement they may have, when they finally settle, they're actually quite happy to have it made public, because that will take away all the fears and suspicions and all the gossips people have as to what really is happening behind closed doors.
Yeah. Thank you both. I'm turning to the chat. I've looked at the chat and we have a couple of questions here. And one is about the different skill set and backgrounds required, as we discussed early on in the webinar, for mediators, and whether you would see that mediation in that sense is also an opportunity for change in terms of increasing diversities of those engaged in dispute settlement. Who would like to start to pick that?
I mean, I think diversity is an issue for right across the dispute resolution spectrum. I don't think it's isolated to. I mean, in arbitration, and I know there's initiatives in mediation. There's similar initiative. So I think that the more that you have these different processes with, and hopefully with a more diverse base, mediating, arbitrating, litigating, and adjudicating, then sure. I mean, I think that will help, because there'll be more processes for people to engage with. But I think we should take it seriously and need to be representative of the companies and society that we serve.
And I think I can add here in terms of the rules background, what the mediation rules have, and that is taken from the conciliation framework that ICSID has, is that there is no nationality limitation. If we look at nationality as a measurement of diversity, precisely because of the fact that as the drafters of the ICSID Convention already foresaw that having close connections to the traditions and customs of the disputing parties might actually be helpful in the facilitation of the negotiations. Of course, that's different from impartiality and independence, which is sort of the basic principle that we have. But in that sense, we may see more diversity on that front. Lawrence, I'm sorry if I cut you off. Did you have something to add?
No. You said very, very important things there about diversity. And I want to chime in here to say that in mediation, unlike arbitration, co-mediation is actually very effective as well. And in co-mediation, you really have two different kind of two mediators cooperating and encouraging the parties along, and that sort of give more opportunity, unlike in arbitration where people tend to think that they are the pale, gray, and old, or whatever term they tend to use to label more popular arbitrators. And in mediation, I've seen people from different age groups, different gender and nationality and ethnicity, and I think there's greater opportunity for diversity in mediation than in arbitration, at least at the moment. I think the door is wide open. There's no age limitation, no nationality or limitation. There's no professional qualification in the sense of you have to be an engineer or a lawyer or a judge, or a former judge. It doesn't matter. So long as you really be trained with some of the skill sets of mediator, be able to learn how to control or help encourage the parties along in the process. I think that is an important skill set, and must have patience. One has to be very patient with the parties and bring them along. And I think co-mediation, I love co-mediation. It's so nice to be able to bounce ideas with a co-mediator.
Thank you, Lawrence. Yeah, co-mediation, just for our participants, is where both neutrals are appointed by party agreement and are both mediators typically to support each other throughout the process. I'd like to point to one other comment in the chat where Arno Gildemeister shared with us that there has been also some advocacy and discussions on the level of the UN tax experts committee that treaty disputes, even state to state, should be mediated more often. And despite the objection that this is a special type of dispute, the awareness is growing also in that context. And we appreciate that, Arno, for sharing that with us. I have been in touch with some members who are discussing on the UN level the tax disputes, and that is where the interesting thing is of how many jurisdictions actually have a tax dispute mediation. So we are approaching our final minute here. So James and Lawrence, what are your final thoughts? What do we need to keep in mind to develop this further? Lawrence, you're still on my screen, so why don't you start?
Okay, let me just say that in order to encourage more non-state entities and state entities to use mediation, what really, as I said earlier, in a macro level, there shouldn't be any, there's really no reason why. But at the micro level, I think the resistance or the hesitancy may come from civil servants or ministers, politicians, because, to suggest or agree to go into mediation may sometimes be seen as selling your state out. So it is something that's not easy for them to come to mediation. But the encouraging sign is if with education, with more knowledge and with more information of what mediation really is, states are becoming more and more open to it. And I think you just mentioned the Singapore EU BIT, or
FTA.
Free trade agreement, FTA, have mediation. And I too want to bring to everybody's attention that the Singapore-Indonesia FTA, also, sorry, not FTA, the BIT, has a specific section on mediation. In other words, states are beginning to realize and put mediation as part of the dispute resolution process in treaties. And I want to see more and more states doing that. And if more states do that, then government servants, politicians who have to make their decision do not need to worry that they agree to mediation. So I think this is a very positive sign. And I think this is the way to go. We must keep talking about it. We must have workshops with government servants, civil servants from every country. ICSID and UNCITRAL can do all these workshops for different state governments and enlighten them. And hopefully they will put all these clauses in the BITs and FTAs.
Thank you, Lawrence. Yeah, that's precisely why we compiled this analysis of mediation provisions in treaties to see where are we, how are we evolved, and to assist in treaty drafting as a tool. James, what are your final thoughts?
I absolutely, I agree. And I think the other thing, I'm enormously encouraged. I've seen a lot of mediation developments start in my time, and all the elements for success are here on the investor state area, because you've got this resistance, and we're talking about culture change here, so it takes time. But on top of education, you've got the institutions are here, like ICSID, playing a key role to give the certainty and the frameworks for the parties to say, well, okay, if ICSID is saying do it and they've got the rules, then we trust these institutions. Let's try it with also the prompts from the treaties and stuff like that. I think counsel play a really important part here. To recognize that actually their role is to help parties resolve a dispute and then decide which is the most appropriate for to do that. It may be litigation, it may be arbitration, or indeed it may be mediation. So counsel have an obligation to broaden out their toolkit and advise their clients accordingly. And then I think when mediations are happening and people start to do it, then you'll see a real sea change, because you'll see evidence and parties will be more confident with it, and then it becomes a bit of a snowball. So I suspect that's how it's going to play out going forward. But as I said, I am optimistic.
And we have already investor state mediations that are ongoing. We just need to, as Lauren said, keep talking about it. So thank you, James, and thank you, Lawrence. It's been a pleasure having you here on our episode 3 on myth busting. And this concludes our webinar for the day. Thank you to all our participants, and I look forward to welcoming you in our episode 4, which will take place on December 8, where we look at investment mediation from the investor and counsel perspective, and we'll discuss considerations of advocacy at that time. So we hope you found it informative and useful, and until we see you here again, be well and thank you.